When we went round New South Wales, we harvested what are a wide range of questions and issues consistent with the first of the terms of references that we were given. They are set out to the extent that we consider they are relevant to informing the debate in the planning system in the issues paper that brings us all together today. Some matters were omitted. Several people who suggested that the foundational document for planning law in New South Wales should be the Magna Carta, unfortunately have not obtained a run, nor have those who were wedded to the Act of Settlement, the Statute of Westminster, the Imperial Acts Application Act and other documents of that nature. We do not wish you, though, to be confined to that which came out in the issues paper, because by and large, the issues paper is in response to the present system. Whilst we are not suggesting that we are absolutely unconstrained, for example, amalgamation of local councils quite clearly does not fall within our brief, nor do we wish you to be constrained in your workshopping today of putting to us matters that you think ought to have been included in the issues that were discussed but were not, or matters that arise concerning the structure of the planning system that are not contained in matters that necessarily immediately flow from the issues paper itself. We should also explain to you a couple of things that we are doing about detail. One of them was announced in the issues paper itself, and that is that a wide range of matters of detail concerning the template LEP and its implementation were raised. That's quite clearly outside the scope of anything that we can deal with, but we did undertake to refer those matters of detail to the local planning panel that the Minister has established, and thanks to the endeavours of Rosemary Bullmore, a departmental officer who has been seconded to us, a schedule of those matters of detail has just been provided to that panel. Similarly, there will be other matters that may arise out of the submissions that don't strictly fit within our brief, but do, at least on their surface, warrant examination elsewhere. For example, we have received one quite short submission from a member of the general public about the classification of particular types of buildings under the Building Code of Australia. That's clearly outside the scope of what we are doing, but we will refer those types of matters to the appropriate place for their examination. We wish you to be broad, and we are not afraid of criticism or radical suggestions. Not everything, however, can be accommodated. We have also received, as we went round on our RSL Club and Steak Sandwich guided tour of New South Wales, and we contemplated publishing a guide to steak sandwiches in RSL clubs, but felt that at least in one instance the laws of defamation did not give us an adequate opportunity to describe what was served allegedly as a steak sandwich at one location. We can't respond to everything. We had some quite novel suggestions made to us, most of which are reflected in the issues paper, but we should I conclude my remarks by saying that the person who suggested to us that the overriding objective of planning legislation in New South Wales should be the implementation of feng shui in the planning of the state is unable to be accommodated, but all reasonable suggestions will be considered. Thank you very much.